Should we start now? Everybody's ready? If you have any, first of all, everybody should be muted. If you're not muted, please do mute yourself. You're going to have a lot of potential questions coming out. And Craig Cordial, who's one of the people who is running this meeting with me, is going to look at them and try to answer them through the chat. So anything that cannot be answered through chat, we will certainly answer afterwards, meaning like after we get off, and you can send us emails, etc. But I want to first welcome everybody to our first ever massive webinar from the Finance Fixer. And this is something which kind of came up because I was going through my own, finances, and someone had mentioned, well, do you have a trust or a will? I'm like, yeah, I have a will. It's like 25 years old. My kids are already grown. I don't have to worry about that stuff. And they're saying, well, ever consider a trust? I'm like, trust? That's just for rich people. I am not rich. I do not need a trust. And so they're like, oh no, you really have to know what this is about. And so I said, okay, teach me. And they did. And once I learned it, I said, oh my gosh, she said, this is something that I need to explain and tell my clients about, because it's something that is really important. And some of you may already have a trust and you're just trying to get more information about, gee, do I have everything I need in my trust? Other of you may be like, gee, I really don't know much. I have a will and maybe that's about it. And some of you are like, yeah, I kind of like have no idea what it's about and maybe I do need it. So we have Alan Ekstrand from our group, the Finance Fixer. He is the founder of the Finance Fixer. He's going to be talking. We have Lester Himmel, who's also part of our group, who's been with us for several years. We have Craig Cordial, who's also been with us, and he is the estate planner. That he is actually certified in estate planning, but he is not a lawyer, but he's the one who's going to answer those tough questions. And we have myself, Debbie Wilder, and we thank you again all for coming. So this is our agenda. We're going to talk about the introduction. We're going to talk about assisted estate planning. I'm going to go into a deep dive into the actual software that I'm talking about. And then we're going to talk about next steps moving forward. Oh, I don't want to forget about Larissa, who is Craig's wife, who is a very integral part of this as well, because she's put together the PowerPoint. So Lester, we'd like you to start. Take it away.
Okay. Thank you all for coming. I'd like to point out that the few people that are here, 20 odd people, congratulations. Nice work. Most people know about trusts and wills and power of attorneys, at least as far as titles go, but don't really do much in terms of creating these things and putting it into some sort of force. The idea of an estate plan really is at the edge for most people of what's called financial planning. What we do generally, and what the public perceives as our role, is simply selling insurance or talking about these things and then encouraging someone to go see an attorney. And I can tell you that the standard response is something like, yeah, I've got an uncle whose brother is married to a friend who has an attorney in the family, and we're going to talk to them probably on Saturday. And then it never happens. So again, nice work. The idea of an estate plan, and by the way, I know this will be repeated tonight, but the idea of using any or all of these documents, I'm going to say it's essential, but the reality is maybe not so much. A will, yes. A power of attorney, more so. Anything that has to do with long-term care, medical directives, that sort of thing becomes increasingly important as we get older. But the idea of understanding all of the ins and outs is a big deal, I think. And the idea of then you as adults picking and choosing what makes sense for you, perhaps with a question to someone like me or Debbie or Craig or Larissa, or any one of the people that you trust with this sort of information or this sort of direction to take, I encourage you strongly to get out there and make sure you check all the boxes and make a decision as it applies to you. Debbie?
Okay, Great. Thank you, Lester. Okay, so we're going to start off also with Alan, because Alan has been through this process before we ever found out about this. He was way ahead of us, and he should be because he got all the experience in the world. And so he's going to talk about what happened with him, what his problem was, how he fixed the problem, and just to give him you an idea of what he did. And Alan, you want to unmute yourself? There we go.
I guess the first thing I would say would be I'm in my 48th year as a life insurance agent, which I find totally incredible. And I hope to be around to celebrate my 50th. But anyway, as you might imagine, I've seen a lot over that period of time. And a couple of years ago, I perceived a big potential problem. For whatever reason, my wife is the owner of all the life insurance policies. Now, maybe I'm just saving the divorce lawyers a lot of trouble. I don't know, but that's kind of the way it happened. And I perceived the problem, oh my God, what if she had a stroke or whatever and was incompetent? I'd be dead in the water. I wouldn't be able to do a thing. Around the same time, she was expressing a concern about, well, what if something happens to you? I don't know anything going on. You know, who's going to help me? What's going to happen? And she wasn't satisfied with the answer that Debbie and Lester would help her and she'd be fine. She needed something a little more concrete than that. And around the same time, a good friend of mine who was a senior vice president at Security Mutual decided to retire and open up his own law practice. The guy was a licensed attorney, and that's his retirement gig, opening up a law practice where he specialized in providing the elder law needs of people, and at a cost that was a fraction of what the average attorney charges. Now, I was very lucky because I knew this guy for a long time and could totally trust him, you know, to help us out. So basically what happened was he had a set of questions, you know, quite similar, by the way, to what Estate Docs asks, that there's a set of questions. There's a meeting with him to go through those questions. Then he came back with a draft and, you know, some more, you know, hammering out of things. And the long and the short of it is we wound up with healthcare powers of attorney, living wills, and what's known as the Extran Family Trust. You know, and I remember he said, well, this is great. Now all the paperwork's in order, but the devil's in the details. Now you have to make sure you fund the trust and that you transfer your assets over. So that involved a little bit of paperwork with the insurance company to get all the insurance policies owned by the trust and beneficiary. That had to be done. We had to change our bank accounts. Our bank accounts are also owned by the trust. We do business with a local Bank of America branch, and that lady actually had to call somebody in the home office to find out how to do it, how to transfer our accounts over to a trust. But that got taken care of. And the hardest thing was transferring ownership of our home to the trust, that I had to have a tutorial from the town clerk or the city clerk here in Torrington on how to do that. That got accomplished. So basically over the course of probably 4 or 5 weeks, you know, all of this happened. Well, I worked on it constantly because the attorney friend of mine kept on top of me to make sure that all of this got done. Now, I'm trying to refer to my notes here. The only thing I didn't mention is one of our concerns was we have no children. We don't have anybody in place, to help us, if we're not competent. So that was another major thing that the Living Trust accomplished, because the Living Trust names 2 younger people as what's called successor trustees. So there's 2 different people that can be called on to help us out if we're not able to help ourselves. So I think that was a very important thing too. Not that you can totally depend on children. I couldn't cite chapter and verse on that over the last 48 years of how it was a mistake to trust children to help out at a time like that. But that was also another major consideration. Debbie, I think I've kind of covered everything. Was there something I missed that you wanted me to talk about?
No, it was just the concern that when, if something happens and you become incompetent or Marie, that's the real reason. That
Yeah. And that unfortunately is a big risk. You might say after about the 3rd or 4th time that situation happened in my professional work, that it finally dawned on me, well, you better pay attention to this, or there could be a huge problem. And you notice I didn't mention that I had an attorney as a successor trustee. No way in the world I would ever do that. And actually the attorney I used actually recommended that I don't have an attorney as a successor trustee, which I thought was a good idea. But it's just knowing that all of this is set in place. By doing this too, I've kind of eliminated probate from the picture entirely. To the best of my knowledge, there will be nothing that will have to go through probate, when the day comes. And in Connecticut, probate is rather expensive. So by doing this, I've certainly saved thousands of dollars in probate fees and avoided publicity. Another thing, having the trust and all the documents avoids publicity. And of course, it's spelled out who gets what and what happens. So there's going to be no fighting over the assets, what's left in the will either. I did forget to mention that. How do I do, Debbie?
Excellent. Thank you, Alan. I appreciate your giving your story. And before we go to Craig, Lester has a couple things he said he wanted to add just for another minute or so. So thank you, Alan.
Yeah, folks, I'm going to give you one bit of advice that you'll hear everywhere, and that's keep documents in a safe place. I'm going to add to that. Let someone know where that safe place is. What happens to people over time is that there's a survivor, and that survivor forgets to let other people know what they have because they forget what they have. Medical directives in particular, I find most of them useless. And the reason they're useless is because you are on vacation in Hawaii, you have an accident, you're in the hospital, and your medical directive is attached to a hospital in Connecticut. The idea of what documents are supposed to do is nice in theory. In practice, they fall down. And we can get into that anytime you wish. But again, when you create all of these things we're talking about, to whatever degree you do, let people know. Family members, trusted people.
Absolutely. Thank you, Lester. Okay, next on deck is Craig and Larissa, who are going to talk about what it is that we're going to talk about today. This
all right. Well, hey, everybody, thanks a lot for jumping on and listening to us talk about something that is oftentimes sort of overwhelming for a lot of people. And the estate planning is not just, well, we're going to do a will and we're going to do a trust. You hear all these terms: will, trust, power of attorney, pour over will, living will, advanced directives. It becomes just absolutely overwhelming, and people just won't do it. However, as a sound estate plan set of documents is fundamental to good financial planning. It's actually what should start good financial planning, because it forces us to ask the tough questions, to plan ahead, to look to the future. What's it going to be like then? And what do I want to leave for my heirs? And most important, have it organized in a time when there's a lot of pressure on you, when there's pressure on the family because someone has passed away. It is absolutely a gift for them to be able to have a set of documents that they can look at and they can say, this is what, for instance, remembrance and services memorandum. This is what my mom and dad wanted for their final, their burial, for instance. Those things are hugely valuable and not something that's been mentioned here in this talk right now, but this is what we want to bring to the table. I'm a certified estate planner, which is a FINRA designation. That's the Financial Industries Regulatory Associate Authority. And that's the entity that licenses people that trade stocks and things like that. So I'm required to maintain my licenses, and I bring to the table a certain knowledge of the estate planning, not from a legal perspective, but from a financial planning perspective. We were able to look at your financial situation, your family situation, and determine pretty quickly, is this something that you can do on your own and save a lot of money? And or is it really something that you should bring in an attorney for? Regardless of which way you are to proceed, it's absolutely a gift for your heirs. That being said, what I heard when Alan was speaking and when Les is talking about these things, I hear, oh my gosh, there's so many moving parts, and how am I ever going to learn all this stuff? And how am I going to get this all together if I'm going to do it on my own, or I'm going to do it with Craig and Debbie, or Alan and Debbie? Well, that's what the software package that we've been introduced to through the Bank on Yourself network, and it's been vetted by these over 200 financial planners and the corporate entity itself. Estate Docs Pro is available in 50 states. And for me, it was really a valuable asset, because I would work directly with attorneys to do estate plans for my clients. And literally every time the attorney would say, oh, here's my estate planning software. You build the estate plan, which I would do. And then they would literally spend an hour or two going over it. We would present it to the client. They would execute it. The attorney would probably say, okay, I'm gonna help you by titling your house into the trust, and he was done. In that process, we're touching every single asset that you own to try to make sure that it's properly funded in the trust, so these documents and the plan works for you. What the attorneys would do, and I'm not trying to beat up on attorneys, but they would determine that, oh, look, this person is worth $1.5 million. This person is worth 7 million. This person's worth 15, and the fees would go up depending on what asset base that client had. To me, that was it just didn't sit right with me. And when Debbie and Alan introduced the Estate Docs Pro software to me, I was really, really interested in finding out everything I could about it, because I had been in several different software packages with different attorneys building these estate plans for clients. The biggest breakdown is literally having the client understand what it is that they're doing and why they're doing it. And that's what the Estate Docs Pro process helps with. And what we are adding to that, not only the software, because that's what you would do is purchase a software package to build your own estate plan, but we're here to help you get through that process. All of these terms and what is the document used for? Why do we want to do this? Questions and answers. While the Estate Docs Pro system literally answers every question that you can have, what we are able to do is be there and assist you along the way. And that's what Larissa is going to spend a little time doing, going through. If you are ready to go now and get your estate plan done, which I encourage everyone to do, it's how long does it take? What are you guys going to do for me to help me get to the end of the game and then fund the trust? Because this funding, which Alan mentioned, is absolutely critical. 80% of trusts in the United States that are formed for families are left unfunded. That means that the client spends $3,000, $3,500 with an attorney creating 150 pages of legal documents, and then the assets are not put inside the trust so that the trust can protect not only the assets but the family. And so it's kind of a disgrace, but the bottom line is that attorneys know that if you don't fund your trust, you have literally nothing, and your estate will go into probate. And Alan mentioned that. I don't know if everybody knows what probate is, but it's a court proceeding and it's a public proceeding. It's hugely expensive. If you have let's just call it $1 million estate, and you do not have a will or a trust, then the state has a plan for you. They already have your estate plan set up, and you can just say about 10% of the value of that estate will go to attorneys, appraisers, the court. And so literally you're losing thousands and thousands of dollars that would be transferred to your heirs. So I think that as we go through this process, you're going to have questions. You can pop them into the chat. I'll do my best to answer them right away. Larissa's going to go through what this process of using Estate Docs Pro, which is your tool, and then layering our expertise on top of that to literally go hand in hand with you to walk you through the process, get your documents in place, and then do the heavy lifting, so to speak, of funding the documents. And most important is that by having us there, it's not that overwhelming. It literally, you can have the entire process done in 30 days. So let me introduce you to my wife, Larissa, and she'll pop through this assisted estate planning PDF.
Thank you, Craig.
Hi, everyone. I'm just, my name is Larissa Cordial. I'm not only Craig's wife, but I am a CFP candidate and a PowerPoint guru. Let's see how I do here. As Craig was talking, one of the things that came to mind that I was not initially aware of going through this process and just starting out was I was thinking of the gross value of the estate as sort of net of any debt. So say, for example, if you have a home valued at $1 million, which in the recent home market increase is not a hard thing to do or to have, and you have still $500,000 of debt on the house, that asset in terms of being valued by probate is valued at $1 million, not the net amount after the debt. So those are kind of some important things to keep in mind when you're thinking about, what do I stand to gain or save by this? Okay, so can everybody see my screen? Assisted estate planning, custom trust documents made certain, secure, and simple. Yep, okay, super. We're gonna see. Okay, so what is assisted estate planning? Craig talked about this a little bit. It's a very complicated process, or can be, right? And our goal is to help you get from here to there as simply and quickly as possible, and that we're going to do that process together. Okay, some of the foundational principles that we believe in, I think that the group in general is we want your process to be certain, secure, and simple. So that's kind of some of the foundational elements that we'll bring as we go through this. Some of the questions that we're going to answer is, why should I use Estate Docs Pro? Estate Docs Pro is the software that provides the platform for this. I think you've gathered by now that we are not attorneys. Estate Docs Pro was created by attorneys, and we'll learn a little bit more about that. Who's going to help me with the process? How long does it take? And how to get started. So why should you use a software, right? Estate Docs Pro in particular. Well, these softwares are being used all over the place now. So from education and healthcare, as well as banking and taxes, software is able to do a lot of things. Alan even mentioned that in his process with the attorney, he just had a series of questions that were asked and he answered. And it's much the same with Estate Docs Pro. In fact, people call it the TurboTax of estate planning. Okay. Sorry, and as I mentioned before, we are not attorneys. Estate Docs Pro software was created by attorneys. It is valid in all 50 states. I should mention that it's going to be valid in the state of your primary residence. And it's not to say that if you live in Florida, it's also valid in Connecticut. It's typically attached to your primary residence based off of your home address and things in that question and answer session. And the process is super easy, step by step, and we're going to go through a quick overview of that here, and then Debbie's going to go into more detail on that based on her experience. Oh, there is a video. We're not going to go through it now. It's about 10 minutes. I know Debbie sent people the link for that video. So if you have not seen that, it goes through it. It mentions a lot of the things that we've talked about here. I'm not going to play it now, but would encourage you to watch that video link that Debbie sent if you have not already. Oops. And now, who will help me in the process? Craig mentioned this a little bit. Hopefully you've gathered by now that we really care about you, our clients, and think that this is super important, even if it's not a case of someone passing away, but whether it's a hospitalization or incapacity, there's lots of things that happen, and it's just a real blessing, I think, to have all these things in place in a time of crisis. So our team here has all sorts of various experience. We always put your interests first in this matter, and we have the added benefit that many of you we already know, right, and have a relationship with. And so for us, it's really important that you get this right, not stress about the process, and make sure that it's manageable and that you can complete it. Sorry, just a few of our really awesome Google reviews. I had to throw that in there. So now, how long does it take, right? The question that you all are asking. And the simple answer is it depends, right? If somebody called you on the phone today from your doctor's office and gave you a terminal diagnosis, knock on wood, I'm sure it would be really quick, right? All of those decisions that you've been putting off would all of a sudden have real clarity of what's going to happen. So to some degree, you know, it can go very quickly, and really a lot of that is up to you. I like to adopt what's called the 80-20 process, which is we want to get 80% of your estate plan done in 20% of the time, knowing that there will be those small details of bequest, who gets grandma's china, or where should which girls are going to get the buffet, or just other types of questions that can sometimes create that conflict or can create delays. Don't let those questions delay you in completing your estate plan. The bulk of the estate planning process doesn't have to do with grandma's china, and we really want to help you set those big foundational elements in place, so that in the unfortunate event of a crisis, that you have this in place and you have that peace of mind. So in an ideal world, we believe that you can get from start to finish in about a month. And we're going to go through that. And Estate Docs Pro actually kind of outlines that process as well. So the first section is kind of a needs assessment. And to some degree, that's what you're doing now. So you can check that off the box, right? You're evaluating to see if this is a good fit for you, discussing it together. If you're married and saying, is this something that we should do? Often that's a phone call, right? If you have further questions about that, and we can do that pretty quickly. Then the next portion of that is called the interview process. And that was that question and answer part that Alan talked about with his attorney. If you have ever used TurboTax, it is the same sort of thing where it asks you a question, you answer it, and you don't know what's happening in the background, but there's magic that's happening in all of these forms that get completed in the end. We break that interview process into 2 steps. And the reason for it is it's a lot of questions. Sometimes they might be hard questions. There are little videos and helpful little question mark guides of what does this mean, explaining that to you. But we break it up into 2 steps to really make sure that all of your questions are answered in this process. And so once we've completed the interview, part 1 and part 2, and all the questions are answered, then you kind of go back, regroup at home, right? Assuming sort of a husband and wife situation, and review, and then finish up any other input for any questions that might still be lingering. And then together, we will review your trust. And Estate Docs Pro makes this really easy, and it has kind of a red flag for anything that's left blank that shouldn't be blank. Blue if there's something that might need a second review or wanting to make sure, did you really mean to disinherit your nephew? I don't know. I'm just making that up, but kind of a good for example. Okay, look at that and double check that. So that's part of that review process, and we will do that together. Then after that process, then really your estate plan is actually completed. And then the next steps after that, we try to do these together if we can. If not at the same time, then in a very short period together. We will, after your estate plan is created, we will then gather all the documents together, print them out, put them together in a nice binder for you. We're typically also creating a digital version of that. We'll add in a few extras like a format for something we call a digital will. It's like a password keeper. Oftentimes people use LastPass, but sometimes if you're not using a software program like that is a password keeper and you want to keep your passwords together, we'll have a document to do that. The remembrances, which isn't always a part of an estate plan, those things like funeral arrangement type of things, as well as powers of attorney, living will, healthcare directives, all those types of things. Put them all together in a binder, make everything labeled, put all those little stickers you see when you sign your mortgage, sign here, sign here, sign here, and then we send it off to you. And then with that, we want to do, when you receive it, you'll go through all of those documents, and then we'll talk about funding. And then those steps that we try to do together would be the signing, which often requires a notary and witnesses, and the funding of at least one asset to get you started. And Estate Docs Pro is really great about having extensive instructions of how to do funding of your various assets. You're certainly welcome to ask us, should I fund my life insurance policy in the name of the trust, or am I good keeping it in my spouse's name as beneficiary? All of those things we can go over on a case-by-case basis. But usually once you've funded one asset, you're more familiar with the process and have a little bit more confidence to do the others. Let's see. And again, just as a reminder, a trust is kind of that box or the vehicle, and it's really worthless unless you put the assets in the trust. So we do want to make sure that you do that. Okay, so those are the 2 steps that you're doing together, right? Or excuse me, on your own: needs assessment, evaluation, reviewing the documents, and doing that along with the self-guided software. And then these are the parts that you're doing with somebody on our team, on our financial planning team, working with you. Having that relationship certainly helps and guiding you through the process. And our goal is to get you to the finish line. Okay, that's all I have, and stop here.
Thank you very much, Larissa. That was great. Again, if people have questions, you want to put them in the chat box, and Craig and Larissa are following it, and they will answer them as best you can. Otherwise, we can always get you afterwards. After the webinar, we can email back and forth or call. So I'm going to be very honest. This is boring stuff for a lot of people. It's not fun to have to think about this. It's anxiety provoking, and you have to start thinking about your death, about incompetence, about all the things you really don't want to start thinking about. And so it's kind of like life insurance, what we do. No one wants to think about it. It's usually not fun. And my goal in my life is to help make this stuff at least semi-fun. So the only way to really kind of get into it is to get into the details and to do it. So the person who introduced me to Estate Docs Pro, even though I started with him, he ended up saying, Deb, you got to do this, was Craig. Craig's like, I'm like, Craig, do I really need to do this? And he said, oh yeah, you just got to learn it. Start looking at the links, watch it. And I'm like, okay. And then I said, yeah, we really do need to do this. And so you guys are going to learn a lot about me. I have my family of 4 with my dog, and and a few things that we have. And I'm going to go right into the software itself and have you see how it works. And hopefully this will help you understand the types of questions that are asked, the things you have to think about in advance, what took a lot of my time and what I blew through. Okay, so I'm going to share my screen here. And hold on, I just kind of screwed up on that. How do I do that? Oh my God, I lost my share. Why can't I share this suddenly? Sorry about that. Here it is. Share. Okay. Okay, so here we go. Estate Docs Pro. This is Estate Docs Pro, the actual software, the actual website. Everybody see me and see what's going on here. Yep. Okay, good. Okay. Now, it's a simple sign-in, just like eventually if you decide to purchase this, whether you're going to go sign in. Okay, and there's my sign-in. I'm going to go in, and everyone's pretty much going to see the same thing. Okay, you're going to see there are several pieces to it. There's 5 basic steps. The interview that Larissa talked about. Then you review the trust after you go through the interview. Then we print and sign your estate plan. And that's all about the notary as well. And you need to fund the trust. And then ultimately you upload this document to what they call the vault. So you're going to have a printed version of this, and you're also going to have a digital version of this. And what's really nice about this is that because it's online, you're going to be able to make changes to it on demand. Oh, my car just died. I had to get a new one. Oh, there it is. I can put it into the trust. And you can just go online and do it like that. You don't need to make an appointment with a lawyer. You don't need to pay anything extra for the lawyer to do that. It's just you can make changes. If your nephew got mad at you, you got mad at your nephew, you can disinherit him right there. Okay, you can do a lot of things on demand. Okay, so what we're going to do is go through this as I went through this. So I started this July 2021. My husband and I went on vacation. I said, guess what we're going to do on vacation? We're going to go through Estate Docs Pro. Can't wait to do this. Craig says it's only going to take 2 hours. So let's take 2 hours from our vacation and let's do it. And so we did. And I have to say what Larissa said is true. 80% of it was done in about 2 hours. And by 2 hours, you're like, oh my gosh, there was just so much here. And it just totally starts making you think about so many different things. So this is what we went through. So we went through the interview, and you're going to see how this actually works and what it's asking for questions. Okay, so there's a whole bunch of different tabs here. Okay, and it walks you through it very easily and tells you where to start. what you're going to need, the name and contact info for your beneficiaries, children, trustees and agents, an hour to complete the interview. I don't think it's an hour, a good 2 hours. And you can come back at any time to finish. Okay. So I said, well, let's just get started. Let's do your information. My husband, Andrew S. Wilder, me, Deborah J. Wilder, where I live in Connecticut County. I'm like, oh, easy peasy. I can do this. Not a problem. Easy questions. Okay. And then what the first thing I had to do is get the name of the trust. And you think that this is an easy thing to think of. It's like, what do we want our trust to be? It should be the Andrew S. and Deborah J. family. Wilder trust should be the Wilder family trust, should be a family trust. And like, it really doesn't matter, but you want to name it something that works for you. So ours is the Andrew and Deborah Wilder family trust. And the date, which is the day that I started in July. Okay. And already the tough questions start. And you're like, okay, what's this all about? If you notice that there's question marks here, okay? And if you select it, you're not supposed to be able to change your trust name after you create it. By the way, you can, and people do, but it's best not to. It's just a little bit of a hassle. And they explain everything you need to know. Okay? The trust date, equal beneficiary shares. Yes, all my beneficiaries should get equal shares. Or no, I would like to determine the size of each share. I've got 2 kids, easy for me, equal share, that's what I want to do. If you don't want to do equal share, then you're going to go through a whole nother set of questions. Do you have a prenuptial or a postnuptial agreement? I'm like, wow, yeah, we actually did a prenuptial 26 years ago when we got married. Is that even valid anymore? I mean, I didn't know it was valid anymore. It's like everything's changed since then. We don't even have half the stuff anymore. But according to Craig, he said, yeah, it is still valid. Craig, you can come on here and say, yep, that's true. So I want to make sure that is still true.
Yep, that is true.
Okay, it is true. And then the question that kind of throws everyone off right away, do you want a standard trust or do you want an AB trust? And again, you question it. What's it mean? I'm not going to go through it now, but wow, the AB trust has a whole bunch of information. And the most important thing is that it's very rare. And it's primarily when you don't quite trust your spouse to be able to handle the finances after you pass away. So you split the trust afterwards into 2 separate trusts. Luckily, I don't have that issue. If you do have that particular issue, or if it's a large estate, you want to possibly look at that. I went with the most common. Okay. Then it asks you, do you want an irrevocable option? Flexibility versus credit protection. With a revocable trust, you do not necessarily have credit protection because you are the owner of the trust. And I am the trust. Someone can come after me. But with an irrevocable trust, I am not the owner of the trust. The trust owns all the property. And that gives you creditor protection. That's a whole nother category. Again, that Craig can get more information in, but in my particular case, no, I'm just going to go with a revocable trust and I'm going that way. There's a lot of pros and cons for both. For me, there are much more cons for the irrevocable because of the lack of flexibility. If you go with irrevocable, it's not flexible. You do have creditor protection. If you go with revocable, you have flexibility and not much credit protection. So important to understand that. Okay, then it asks, well, upon the death of your spouse, do you want to have this trust remain open for future amendments or even dissolution? And you have to decide, is my spouse going to have unrestricted access to assets and make changes to the trust? Or are you going to lock it down and say, nope, no changes. My spouse does not know what she's doing or he's doing. And nope, nothing's going to happen. Okay. Do you have separate property that you wish to keep separate? What's all that about? It's usually acquired before marriage. Okay. If you select yes, your property assets will maintain its character. It was separate, or it becomes community property, basically. Should written consent of both spouses be required for all transactions? Do you want to void this trust in case of a divorce? Wow, we just got stunned at that point. Divorce. It's like, we don't like that word. It's like, what's that even mean? What's it mean to void the trust? I had to call Craig. I'm like, Craig, what's that mean? And so he says, hey, listen, in case you get divorced, do you really want all the stuff that you said to happen? It's like, well, not really, because everything's going to change. I don't want everything to go to him if I get a divorce. And of course, we're like crying, practically saying, we don't want a divorce. It's like, it's very emotional to go through something like this. So we decided that the best thing was to void the trust, because obviously things will change dramatically if you get a divorce. That's what we decided. Okay. Do you want a single individual or organization to serve as trustee with an alternate or a committee? And this is one of those really hard questions. You got to kind of read the whole thing through. Finally said, nope, I'm going with one successor trustee with alternates. I don't want committees of people. I don't want that whole committee thing to happen. Okay. So we're only on page 2. After it was so easy in page 1, I'm like, oh gosh, this is getting
Holy
really hard.
shit.
Okay. So now we're going down to your children. Okay. So we start talking about a list of my children. I could deal with that, easy enough. Okay. My son and my daughter, easy enough. Next, we have distribution options. Do I want a joint trust for the children versus outright distribution at any age? Again, you have to understand what that means. If yes, and for me, it was yes. My kids are 20 and 23 years old. I don't want them getting $2-3 million of death benefit out of the gate at 20 and 23 years old if my husband and I die at the same time. I don't want that happening. So I decided that they're going to get distributions, a third of each trust at these final ages. So my daughter was that age first. Okay. Somebody I think has their microphone on. I'm just wondering who that might be, because I'm hearing some things in the background. Just check your mutes to make sure you're muted, please. So we have the different ages that you could do. So first, when my daughter turned, if we die tomorrow, my daughter's not 24 yet, so she would get it first. My son's only 20. He has to wait till he's 24 to get it. That's how this is working. So he's got to wait 4 years. She's going to get the money now. He's only 20. He's got college and all that. Okay. So this is really interesting. We spent so much time figuring what age that would be, and we finally came up with that. Then, okay, things may be earlier delayed. Life happens, and maybe they need the money before the distributions happen. So they ask you, would you like to have early distributions for extracurricular activities? Well, yeah, my son might go into a tennis tournament and may become, part of the U.S. Open. And yeah, if he needs money, please give it to him. Okay. Matching scholarships for college, education expenses. You want to set a minimum GPA that they have to reach to get extra money. Who'd ever think of something like this? They really get into a lot of detail here. Health and medical needs. Things which unfortunately happen, drug and alcohol addiction. Do not distribute until they're clean, because obviously we know what they're going to use it on. First wedding expenses. Yeah, I'm going to give them $75,000 for their wedding and honeymoon. They'll be happy with that. Their first home purchase. Yeah, I still think it's too much, but that's what we decided on, how much we'd give them for their home purchase. Early business for a business startup. My son wants to start his own restaurant. I certainly want to help him do that if I'm not here. For church missions, I don't do personally church missions, so I said no. Okay, but you certainly can say yes. Okay. Then we get to the roles, and they start talking about what is a trustee, what's a successor trustee, what's the healthcare agent, what's the financial agent, who's a guardian. And guardians are for kids for under 18 years old. Who's going to be the person taking care of their financial and health well-being? It could be 2 separate people. So the trustee, just for the easy part right now, while I'm alive and my husband's alive, we are the trustees of our trust. If one of us dies, the other one remains the trustee. When the second person dies or we die at the same time, then new trustees gets selected, and I have to figure out who's that person going to be. Okay, that's called the successor trustee, the person who's going to take over. Will it be my kids? If they're old enough, they could, but they're not old enough right now. They are not becoming the trustees. I can just imagine what they would do with the money at this point. Okay. Healthcare agents, in case you become incompetent, who's going to decide if they're going to pull the plug or not. Who's going to decide what kind of treatment you're going to do? You want to have this in advance defined. It's called the living will. They will ask you in the hospital, do you have a living will? You can say yes, but usually they want to see a copy of it. So it's one of those things you, like Lester said, where is it? Who knows where it is when it happens? Who knows? The financial agent, a durable power of attorney for finances. If you're not able to write out the checks for your bills, somebody's got to do it on your behalf and write their name on the checks on your behalf. Somebody has to, if you need money for a chronic illness and you call about your life insurance plan, say, hey, I understand that we have a death benefit that we can use because my wife is now critically ill or chronically ill. Can I please have $1 million of my death benefit? And they're going to say, well, are you allowed to do this? No, she's the owner of the policy. Oh, we're sorry, we can't do it for you because you're not the owner. You don't have a right to do it. You need to have a trust or something that says that you have power of attorney over her affairs. This is huge, very, very huge. Okay. Then you start adding more people to this plan. So they say, do not add your spouse here, do not add your children here. You're going to add the people who are pretty much going to be your successor trustees. So I have my sister and my brother-in-law, they're married to each other, okay, as my successor trustees, but not together. First, it's my sister. I just want one person because otherwise it's a committee of 2 people. And if my sister and brother don't agree on how the money should be distributed to my kids when I'm gone, they're screwed. No, they're not going to get it. They're not going to get anywhere. So I want one person to make the decision, and I have to trust that person. So if my sister dies, then her husband takes over and he makes this decision. Okay. This was originally my husband's best friend. He lived in New Jersey. And we were positive he was going to want to do this. Positive. And so we called him up and we told him the whole story. And he says, not a chance. He said, no way, Jose. My mother just passed away. She didn't have a trust. She had a will. And it's been a year that I've been dealing with this and I hate it. And I'm not going to be doing this. But it was a will. It wasn't a trust. It was a whole lot different, but it wasn't good. And we're like, who are we going to use? And we went through all these different people before I actually thought of my brother and sister. And I had to trust in them to do something like this. So that's going to be your number one question is who can you trust? And according to Alan, it should not be a lawyer. It needs to be somebody else because it's probably going to be very expensive for a lawyer on top of it. Okay. And no one says, by the way, that you can't pay your trustees, your successor trustees, something for taking care of the trust. It does require some administration. So you certainly want to keep that in mind too. Okay, so that's who we have. Then I went to my beneficiary selection. Okay, and they talk about spendthrift provisions, which gives, this is really neat. It's a video that they give in the middle of this thing about what spendthrift provisions actually are. So I'm not going to go through it now, but they tell you what that means. And they say, okay, who are your 2 beneficiaries? I want my daughter and my son to be equal. Easy enough. Okay. The famous disinherit. Okay. So if there's somebody that you don't want inheriting anything, you specifically list them here. It is allowable and it's in the trust, and they really can't, unless they can prove that you were incompetent in doing this trust in the first place, you've got a lock on this. It's like, they're not going to get much. Okay. Or anything. Whoops, sorry. How do I get down there? Okay. Then we went down to trustee selection. Okay. So now I've entered my sister and brother-in-law as the trustees. We need to know, well, how is this going to work? Well, my main trustees of my husband, if he dies, I'm his main trustee. Okay. Okay. If I'm no longer alive, then my sister becomes the main trustee. If she's no longer alive, then her husband becomes the main trustee, the one taking care of the trust and in charge of distributing the money. okay, are the assets. Then reverse for me. If I die, then my husband becomes it, and then again, my sister and my brother-in-law. When my kids get old enough, I will make them the trustees. That's going to be a long time before that happens. So they're only 20 and 23. They got to be in their 30s and maybe even 40s before I even think of something like that. Okay. So this took the most time, and this part, the trustee part, threw us for a loop. We finished all this and we thought we were all set with my husband's best friend. And we were just like, wow, we're all set. This is so easy. He's like, no, I'm not doing it. It's like, oh, now I don't understand what I should be doing. So this took about, this part took about an hour right here, and took a break and came back and said, okay, let's keep going. And now we have financial agent. And then you're starting to think about, well, who's going to be in charge of the finances, if people aren't competent? And we finally decided that it was going to be the same people who are going to be our trustees. It's going to be me if my husband's not here, and then my sister, and then my brother-in-law. Then if I'm not here, it's my husband, my sister, and my brother-in-law. Okay, that's okay. And they talk about what a financial power of attorney is up here. Again, another nice video that you can watch about it. Then we talk about healthcare agents. Ooh, this was a tough one too. So who's going to make the decision for you? Choose carefully, because your agent can terminate life support systems even if you are not terminally ill. They go through a lot over here. You can choose from family, friends, and other people you entered earlier. So it could be your neighbor who you really love or trust or anything. We kept it to our kids. And so we decided that, okay, if my husband is, ill, I'm going to be the primary person making the decision. And if I'm not around, then it's going to be my son. And if I'm not ill, if I'm ill, then my husband's going to be the main one, and my daughter is going to be making the decision for me. Okay. That was not easy to decide, by the way, because one person, you can't have two. I guess you could. I guess that's it. You have your alternate, and that's it. The ones who you chose in here, that's what you have. And you start having to think about relationships between you and your kids. And, you think that everything's always hunky-dory. It's not. You always have to think about these things as you're going through this. Okay. Advanced directives, end of life care directives. Okay. Again, here's another nice video to reach. You'll make an, oh gosh, hold on. Okay, continue working. I hope that we don't get logged out. My goodness, I have unlimited. So I don't know if we get logged out, everybody just log back in again. I apologize if that happens, because I have unlimited time here. So we'll just keep working. Okay. So with the end of life care directives, okay, this is all about if you're ever in a terminal condition, a persistent vegetative state, or an irreversible coma. This is what we're talking about here. It's scary stuff. Okay. It's what do you want to happen to you? So do you want all measures taken to prolong your life? And if yes, skip on to the next tab. Or no, I want limitations on medical treatment. Okay. So yeah, I want to have all measures taken. I want to live as long as possible, but I don't want to be a real burden, but I make changes later on. You never know. Okay. If no above, the following questions are required. So I did it. I answered them anyhow. Okay. But I said, no, I want to specify the following treatments. I request resuscitation and life support. And what's that really mean? Okay. I request artificially administered food and fluids. I request emergency transport. Pain management, absolutely pain management. I have zero tolerance for pain management. Okay. Then we go to organ donation. Okay. Do you want to have your organs donated? For me, no. But if you do say yes, you certainly can put in whatever you like per person. Guardian selection. If your kids are under 18, who do you need? They ask you who you want. So again, you would have put these people up in advance, but they're old enough, they don't need guardians. And there's also an option to enter as adult disabled. Okay. And you can select that a child is adult disabled, a special needs child. I do not necessarily, and this is part of the needs analysis that Craig was talking about in the beginning. Absolutely, you need to talk to somebody about anything regarding special needs trusts. It's a whole nother ball game. This is not necessarily the right thing for them, but we want to make sure that you understand what you can do and what it can provide versus going to a special needs attorney instead. Okay. This is probably the most fun part, if there is such a thing as a fun part of doing this. Okay. You need to decide a bequest. Okay. Now, a bequest is not the same as leaving money to somebody. A bequest is, I have something specific and I want my daughter or son or neighbor to have it. And it could be of high value. And that goes to them first before any of the other money is distributed. So I want to be sure that my kids get all the things that are of worth in our house, which there isn't a whole lot, and make sure they have the emotional attachments to it. And then all the rest can be sold and then distributed to the kids. But I first want to make sure that each child is going to get what I think that they're going to want. Dad's record collection of LPs and 45s going to my son. My diamond wedding ring going to Bonnie. There are scrapbooking books. There's a lot of money in scrapbooking tools and books. Dad's air checks, which are all self-made, by the way, but very sentimental. Newspaper and autograph collection. The treadmill and the elliptical, we just bought those. Those are a hefty thing. Definitely my daughter who's going to physical therapy is going to want this. And then we have the house. My son made it clear he'd love it. My daughter made it clear she doesn't. I'm like, perfect. We'll keep the house. We'll do the house for you. And then we can keep adding. And this is a part for the 80-20 rule Larissa was talking about. There's millions of other things I could put out here, but I just can't think of them all at this time. I put ton to start. And then you can go and update it as you please. Other options. Okay, so this is all about the burial, the death part, the part that's really hard to talk about. Okay, this is not critical to be done as part of this now. Here are specific directives we wish to have carried out upon my death regarding my funeral and burial. Here are my thoughts and feelings. Okay. Same thing here. This is all they give for Estate Docs Pro. There's a whole host of other information that we actually include separately, that we can include with the trust, when we upload it to the vault, that asks you a lot more detailed questions. For example, what kind of headstone do I want if I haven't purchased already? Where do I want to be buried? Do I want to have a wake? Do I want music at my wake? Do I want to have catered food from Angelico's? And do I want it to be pepperoni pizza or vegetarian pizza? You could get down to that type of detail on everything regarding any part of your funeral, including who should be notified upon my death. How should my obituary be written? Do I want to leave a video to my kids? Do I want to keep it updated? You can already see there's tons of things you can add, and that's an extra 8 or 9 pages that we include with this as part of purchase with this, that we want you to really think about, but again, is not critical to getting the trust done. You can keep working on it in the background. Okay. And then finally, we do a review. And that's the review on that calendar that Larissa was talking about. Your information, it tells me everything was here. 2 beneficiaries selected. Am I sure this is the blue she was talking about? Are you sure you didn't want to disinherit anybody? No, don't want to disinherit anyone. You sure you don't want any guardians? No. I didn't put my information here because I put my information in the other 8-page document that I had. Okay. And if review is complete, click here to continue. Okay, it's complete. We're good. And then it goes and basically says, okay, here's everything. And we're back at the beginning again. Okay, you go back to the welcome and we're starting all over again. And here you can say, oh, you're going to go through each one of these and you're going to generate a document. You're going to click this and you're going to generate a document. It's going to be a PDF. That's what it is. Each one of these has it starting from here. You can edit it if you made mistakes, or you can generate the document, which is just, again, a PDF of X number of pages for your state. Okay, it has all the right lingo for Hawaii, Alaska, Florida, whatever it is, it has the correct lingo for that state. Okay, if there's something that you want to upload, then you can do that as well. You can upload to the vault. And the signature required, I chose to show it on every page that a signature is required, so I know where I have to sign. Otherwise, I got to read through the whole thing and figure out. Otherwise, it's in bright yellow and it's easy to sign. I'm going to show you what it looks like. So for every one of these, you're going to generate the document and it creates a PDF. And I think I can actually click this and open it up. And voila, there is a certificate of trust. And it goes through the table of contents and it goes through everything up. And there's my little signatures here. It's like, oh, this is great. I don't have to worry about where I'm going to sign. It's right there. You don't have to have that there. I personally do. Okay. And you can see that it needs to be notarized. Okay. So we go through and it goes through all the stuff here and it's all here. Okay. So every one of these is several pages long. Okay. And each one of these, oh, the last will and testament. I wanted to mention that. So what about the things you forgot about? What about, you meant to bequeath, not bequeath, but you just forgot about a car or something that you don't remember you were supposed to put in the trust and you didn't, or something left over. And I don't have a great example of that. Maybe Craig does, but it goes into a will, but it's not the will that you're used to hearing about. It goes into a pour over will, which goes inside the trust. So in case you did forget anything, at least it's still inside the trust and it's hidden from everybody. It's private, like everyone was saying, and it doesn't have to be brought out to the world. So things you've forgotten will go to that pour over will. And then you have the financial power of attorneys, the healthcare, the living will and directives, and then you've generated all this. And at this point, you're going to stop because there's the blue and then it says stop at the red. And your advisor, who's ever helping you, Lester or me or Craig or whoever, is going to help you and give you choices at this point of what you want to do with this beautiful document that you just created. You need to get it notarized. You need to print it. And so in the end, Craig did a phenomenal job. And he, whoops, I got to turn off my background here for a second, if I can. Well, let's see if I can get it just right so people can see it. No, they can't. Oh, there it is. No, hold on. Sorry about that. Let me get my stop share for a second and get my background to be plain. There it is. Okay. The Andrew and Deborah Wilder Family Trust. And Craig, I was like Craig's client for this. Okay, so he actually sent this to me by FedEx, a beautiful binder. It had an opening in here with a letter telling me, you know, thank you, you did a great job, and here's all your documents. Okay, and he gave me also this right here. This is everything of my trust is sitting on here. So I have a digital copy as well sitting in my house, so it's not necessarily on the web. Okay, and then it has basically what you kind of see here. It says the revocable living trust, the certificate of trust, last will and testament, financial durable power of attorney, etc. And the etc. is other assets, real estate transfer deeds. You know, all your information is going to be put in this really nice binder all together. And he also sent it to me. You can't see a whole lot of them, but there's one right there and one right there. The sign here's. He put all the sign here's here, so I know where to sign. Okay. In addition to seeing it on the actual trust. Okay. Okay, let's go back to, hang on one second. And there we go. Okay, so let me go back to share. I see that there's some chats. Are they all being answered? Craig, do you see all the chats that are going through? I just want to make sure.
Yeah.
Yes?
Yes.
Excellent, thank you. Okay, so we generate the documents and then we send you this really nice binder. And then you need to go and get a notary. Now, you could use a mobile notary, somebody who physically comes to your home and he'll go there and sign all the documents. He'll bring a witness if you need a witness, because some states you need witnesses, others that you don't. Some states you need 2 witnesses, okay? I didn't know about that, but I just decided to go to the bank where I do business. They didn't charge me. They could have charged me. A mobile notary will charge you. It's in the $100, $200 range, maybe 300. I'm not exactly sure, but it's in that range because someone's coming to your house and it's their time. But it all gets done right then and there, and you don't have to leave your home. It's very convenient that way. I went to the bank. So I went, so now comes the rest of the stories, okay? So I go to the bank and I tell the guy, okay, here, I need a notary. And I took it out of the binder, figuring it's gonna be easier to just give him the pages that I need. Well, that was a mistake. Don't take it out of the binder. That's mistake number one, because it got all screwed up in different, different areas. He kept throwing them to the side. I'm like, wait a minute, you got to put with that. And in the end, I'm like, oh my God, I have no idea what page goes with what anymore. And it taught me a lesson, because what happened was I went through this whole thing, did everything it told me to do with the State Tax Pro, and I didn't really read the final product. I didn't want to read the final product. It's kind of boring, and dull. It's like, I put all the information they asked me, don't make me read it now. I know what's in there. But guess what? I had to figure it out. I had to read it, at least the titles and what it was all about. And I'm like, oh, wow, it's only 6 pages. That made sense. And oh, look, here are my bequeaths. Oh, here's my husband's and here's my, oh, this makes sense. And I actually was so happy that it actually got all out of order, because I had to put the whole thing back. And I'm like, oh, okay. Now I see what's going on. This actually makes sense. So as much as you don't want to read it afterwards, I would suggest that you do. Now, unfortunately, this, by the way, it took like 45 minutes for the notary to get through anything. And I got there at 4:30 when they closed at 5. They were not happy at all, but they were there and I needed some witnesses. And I literally took some people from the counters and said, hey, I need you as a witness. Can you please put your name and address here? And they obliged, which was nice, except that when it came to the healthcare directives, there's a part in there that says, you are, the person who is asking you to witness this, and you feel that she's competent. And the notary refused to notarize that, because these people I pulled off from the bank. So I'm sitting here with some unsigned parts of the healthcare directive, which is not part of the trust, by the way, but certainly if I need healthcare, I better go get that signed. But it just goes to show, with Larissa saying, you don't have to finish everything in order for this to actually go into effect. Okay, so that was my little story with that. And it's important to know that things can definitely go wrong with the notaries and how long it takes and getting out of order and all that good stuff. So then we went on to the funding kit. Okay, as I wrote in the email, if you just have this beautiful binder here and it's sitting up on your shelf and something happens to you, it's an expensive piece of worthless documents, because there's nothing in the trust. You want to fund the trust. And the first thing you should fund it with, if you have one, is your house. So I'm like, okay, I promised my clients I would do this before I did it, before I present this webinar. So I went through the whole house thing. I'm still in the middle of it, by the way. Okay. And what happens is that it asks you, here's your kits, by the way. You have your real estate assets and you have all other assets. So you click real estate assets, okay, and it gives you information about it. It talks about what a deed is, all that stuff there, okay. And then it says that in order to do it, you need to go to the deed service tab for more information and pricing, because they have a partner with the National Deed Company. And that partner is called DeedWorks, W-E-R-X, DeedWorks. So I'm going to bring up what my DeedWorks document looked like, so you have an idea, okay? And it's kind of small, so let me make this big here. Okay, how do I make this bigger? Let's see. How come I can't do this? Okay, I can't seem to make it bigger. So I apologize. I'm just going to leave it like this for now. I know there's a quick zoom button here and I can't find my button for that. So I apologize. Okay, so basically what happens is you're going to get a deed preparation, which cost $125. My recording service for the deed, which is $55. The county recording fee of $58, and the local form completion service for a total of $283. Do I want to do anything with this house and deed? Not a chance. I don't want to go to the town office. Alan did the town office thing, and he had a long time before he got that house in. I'm like, you know what? I'll pay for that. Someone can do that for me. So I paid for it to do that. And then you have to give all of your information here about the names of who you are, and it's the deed type and all that good stuff. So we help you actually through this and to figure out what this is all about. You have, hang on one second, I'm going to try one more thing. I guess I'm going to do that. So anyways, it asks you the property type. It actually asks you for the tax ID, like the parcel that your property is on. Okay, you may not know that. If you don't know it, they'll research it for you just for another $50, $60. I had my physical deed with me, which had it on there. So I uploaded my deed to say, hey, I'm saving myself $50. You can have them research it for you. That's okay. So this type of information is all on there. I can't move it up, I'm sorry, but this is what I have on here. But this gives you, we will help you through this. And I submit it, I press the button, I give my credit card and I submit it. And I wait. And I wait. And then suddenly I got an email from them about 6 days later saying, hey, we need your social security numbers. I'm like, oh, I didn't ask for that. Okay, call this number. So I call the number and they say, we don't have you in our system. I'm like, you got to be kidding. And so they gave me, so we have a number for you. And so I called the number and I got the guy who absolutely knew what he was talking about. Why did he know what he was talking about? Because it was the owner, the person who had the whole concept and wrote Estate Docs Pro. He's like undercover boss. He actually is on the front lines wanting to make sure that this works correctly. And I told him what happened. I said, it sent me off to someone else. And he explained, oh, I apologize. Thank you for telling me. We're going to fix it. You actually can get a hold of the owners if we really need to. And we'll do that on your behalf in any type of very interesting, situations. But just goes to show nothing's perfect. However, he absolutely answered every one of my questions very clearly, very well, took care of the whole thing and said, I'll take your social security numbers and I'm even going to put a rush on yours and you're going to get it within a few days. I said, perfect. I said, couldn't ask for any better service. So that was my whole thing with the house. Okay. Then instead of the house, then we're going to go into, hold on. There it is. Oh boy, hang on. I pressed too many presses. Let's see, other options, review, click. And we go to the funding kit and then all other assets. Okay. So this is where the next thing I want to do was change my life insurance policy. Well, my 13 life insurance policies that I have. I do sell life insurance, I believe in it. So I needed to go and I basically went to my admin person, which is what we would do for you. And we'd say, hey, we need to change the ownership from the owner, Deborah Wilder, to the Andrew and Deborah Wilder Family Trust. And so we put the paperwork in for that. And we also make the beneficiary the Deborah and Andrew Wilder Family Trust, so that the trust owns it, the trust receives it when the time comes. And there were a few things that Alan had mentioned. He said that he needed a new checking account. And you do, and you should. And I don't want to say you have to, but you absolutely should have a trust checking account. And Craig can probably give more information about that. And that's one thing is a checking account. Another thing to consider is, do you want to put everything into your trust? And that's a discussion that you have with your advisors, because sometimes, for example, if you want to put your house in the trust and you plan on selling your house in 6 months, don't put your house in the trust yet. Because in order to sell it, you got to take it out of the trust, and then you got to sell it, and then you take the new one and put it in the trust. So it depends on how long you have your house for if you want to put it in right away. Okay. Other documents, like for example, things that are jointly owned. You may put your kids on your checking account. You don't need to put the checking account in the trust. As soon as you die, they still have access to the money. There's no probate with that. It's theirs to use. Transfer on death is a whole nother option that you need to understand and know about. And that's the part that's kind of, it's frustrating because you just don't know exactly what to do. And you have to really learn about that part in funding it. You can go to Fidelity and say, I want to change my beneficiaries, and maybe they'll be able to help you understand it as well. And they'll also certainly be able to help you with the paperwork. But you really want to make sure that you understand it very well. And we're here to help you with that. Okay. So they start talking about the instructions, the guidelines, what you do for your cash, checking, savings accounts, CDs, your vehicles, your insurance, your life insurance, your disability insurance, employer, pensions, annuities. Again, not everything has to go into the trust, but probably 90% of it should, but not necessarily. Everybody's different. For me, probably everything's going to go in. No reason that it shouldn't in this particular case, except for my joint accounts. Okay. So this is the part why you see it's so important. And this is the part when you go to a lawyer and pay, depending on how much you're worth, like Craig was talking about, oh, it's going to cost you $2,500. Oh, it costs you $10,000 to do your trust. Oh, you're worth $10 million, $10,000. That's my going rate. And that doesn't even include moving money into the trust. That doesn't include funding at all. Oh, you want me to fund it? Another $500 for each one of them. Well, you didn't say that at first. Well, that's the way it works. And you're stuck at that point. You're like, I don't know what to do now. You just keep paying it out. So this is very hands-on, very do-it-yourself. You understand it very, very well. And maybe you don't. Maybe you don't want to. Maybe you don't like to. And I completely understand that. This is definitely can be very overwhelming, especially if you want to get it done in 1 month, according to the ideal Larissa timeline. Okay. I finished it 2 months ago. Okay. I'm still in the funding stage. So that took me 6 or 7 months, and I'm a financial professional. I do not expect you necessarily to get it done in 6 weeks, but I can tell you that's all I thought about. Oh, I got to get the trust done. I just got to get that answer. I just want to finish it. You want it off your shoulders because it just hangs over you. Because once it's complete, it just feels so good that every one of your affairs is in order. And that pretty much tells me about everything. I went a little bit over than I wanted to, but the document vault here is where you finally bring in all the documents. So basically everything that's in here is now up here, and it's on here. So I have 3 locations for my trust, and I can make a change at any time I like to. Some changes require just another witness signature, so that's not a big deal. Other changes require no signatures, and other changes require you to go back and notarize that whole section, if not the whole thing. It depends on what you're changing. Like dropping a whole beneficiary is going to require, or adding a beneficiary. So I want to stop here, and I thank you for listening to all that. And I hope it was very helpful and hopefully a little, not so very informative. Hopefully it was very informative and also fun, because it's very hard to make this fun. So Craig, I want to bring you in, and Larissa, because I'd like you to answer any questions that maybe people had that people are asking about. You're muted.
There. Yeah, we had several questions, and I think most of them were related to funding issues. And as you saw in Debbie's presentation, the funding section is very detailed in Estate Docs Pro, and I think it's the most valuable part of the whole software package, because it literally walks you through every single asset and gives you the answers, for instance, that several people were asking. Most important, though, is that it helps you to just going through the process. Even though Debbie said, well, you may not understand, you may not even want to understand it, you will understand it. And you will understand these documents and the value of them better than almost anyone that goes to an attorney, because the attorneys just do the documents, they sign here, they help you fund maybe one asset, and then they hope you won't fund the rest. Because the bottom line is that an unfunded trust goes through probate, and probate is the attorney's retirement fund. So they don't have any incentive to help you down the road unless you want to pay them a lot more money. It's unfortunate. So
Those related to funding, right? That was the main.
yeah.
Okay. We can ask if anyone else any questions they want to put in the chat box. We can take a couple questions now. If there's anything else out there, let's just wait a couple, a minute, 30 seconds or so, see if anyone wants to write anything. Because we're going to continue on. Larissa's going to go and talk about how to get access to this.
Parkinson.
Go ahead.
Deborah, this is Wayne.
Yeah.
We have a special needs child, and we do have a special needs trust. And we did ask the question of how it coexists with that trust, because Vanessa can't be named on any,
Assets.
yeah,
over
she can't have any
$2,000.
assets.
Yes.
So,
And Wayne, I have an answer actually for you. When I talked to the guy on the phone that time, I asked him specifically that question. And you
Okay.
are actually well set with that. I will tell you how to handle that.
okay,
All right.
okay.
Mhm. I wasn't sure if I fully understood Craig's answer. Craig, I'm sorry. I didn't know if I understood what you were saying in your answer. So that's why we're asking.
Sure. So is that related to the Medicaid issue? The 5-year look back? No.
No, I don't even know about that. I didn't know what that was all meant. We're her guardian. We're her legal guardians.
Mhm.
And she's 29 years old. So she's not under 18 years of age, and she's with us for life. Okay. And so when we set up a long time ago with our wills and stuff, if anything happens to us, she can't get anything. So we set it up as a special needs trust for her.
Right.
So we were trying to figure out how this works with this trust, because,
It will work.
after you go through all that stuff and you put all the names of who you want here and that sort of thing, we can't put her
You
name in
can't put
there.
her name in there, yeah.
Sure.
Yeah,
So
we'll-
there's a process that Estate Docs Pro has developed to handle that particular situation.
Okay.
Oh, okay.
And it includes just a couple steps of disinheriting the child, and then there's a trust that's formed into which your trust would be titled. So, and Debbie can explain that to you. She
Okay.
Yeah, that's
All
nice.
right.
was with the owner of the company and went through it in detail with him.
Yeah.
Oh,
yeah,
okay,
that's
great.
fine. I
Yeah,
just
no.
wanted you to know I wasn't understanding where all of this other stuff was coming from, because I didn't know anything about the medication.
And also, I want to bring up one thing which I also learned, and that is that trust. So the trust doesn't become in effect until the owners die. Okay, we can
Right.
have a trust, but as long as I'm alive and my husband's alive, the trust is basically inactive. We have money in there, but it doesn't go into effect until both of us die. At
Correct.
that time,
Well-
okay, when both of us die, then the trustee takes over, my sister, for example, then takes over, and depending on how old the kids are.
Right.
Now, I found out, and I had no idea about this, I want to tell everybody on who's on right now, is that any type of earned income inside the trust that's not already tax-free, life insurance is tax-free. But if you have put it into a CD because you got a death benefit, and now that CD earns some money, the trust has to pay taxes every year on that money, on that earned income. And trust tax rates are very high relative to individual 1040, like the Form 1040 tax rates. The trust tax form is called the 1041, okay? And so just like we have our 10%, 12, 22, different marginal tax rates, if you earn over $13,500 as of today on your trust income, you're going to pay 37% taxes on that income. Crazy. Why is this happening? Lester told me why, because the IRS knows what you're trying to do. They know you're trying to protect your money from taxes. And if you're going to go and use that to earn all your income, they're going to get you right at $13,000, 37% of it. Okay, it used to be 50%. It's on sale now. Okay, but either way, it's a lot. Okay, whereas if you take a distribution of the money and put it into your own checking account and you put in a CD, that's the regular normal tax rates. So you don't, the goal of the trust is not to have it grow unto itself, but to house the money, be very safe. Don't have a lot of taxes being paid by the trust. You don't pay that individually. The trust pays it. So it's basically eating into your trust, okay, as you're paying these things. So want to let people know about that. Craig,
Okay.
anything else? Any other questions from other people?
Thank you.
You're
Debbie.
welcome.
There are a couple.
Yes,
Debbie, I've got a comment.
yes.
Number one, life insurance into an irrevocable trust could be problematic. Let's not assume that it's an answer to everybody's question. Revocable versus irrevocable, different scenario, different treatment of life insurance, and most specifically, different treatment of being able to access money to pay your bills when the time comes, if the time comes, for example, in retirement. Additionally, what was laid out here is quite a bit of information. It takes months, in your case, at least hours to fill it all out. But the point must be clear that down the road, if you do this in April of this year, in 2023, in 2024, in 2025, and every year, you've got to review what you've set up and make changes where appropriate. Guardianship is a big one, for example. The idea of assuming that once you've done all these documents and all these plans, they're chiseled in granite is a mistake. It's a massive mistake for many people. And the idea of, again, getting these documents positioned in, for example, the Estate Docs Pro Vault, whether you have a digital version or a hard copy at home, is not the important part. The important part is someone who, in your stead, for your benefit, is ready to take care of whatever needs to be done for you if and when the time comes. That's imperative. And having this locked up somewhere in a safe place is not the answer. If someone doesn't have access to it that should, that's a problem. And as Debbie was pointing out in her plan, the idea of going to a best friend or a relative and assuming that that individual is ready to do whatever has to be done for the next 40 years might be a mistake. Every year you review the situation. Estate Docs Pro, in actual fact, to that end, is a benefit because you can make changes very easily. If you set one of these plans up with an attorney, imagine what kind of difficulty there will be going to an attorney's office and paying the fee for changes every year. Well, that's a little bit crazy. But again, just keep in mind, these plans are good for as long as they're good, not forever.
Very good point. Thank you, Lester. Thank you.
Yeah, a lot. Like Les was mentioning, this is a living document. Estate plans are not something that you do and then you shove them into a drawer and on your desk. It's literally part of your life. And every year you should review this with your financial advisor. And that's another advantage of having us working with you to develop the plan, your estate plan, because we're with you all the way, helping you make those decisions, asking the right questions. You got to remember, laws change. Laws change per state. And it's really important to make sure that when for instance, ICOM asks, what if your life insurance policy already has beneficiaries attached to it, what's the point of putting it in a trust? Well, it's specific to whatever is happening with you versus another person. For instance, if the beneficiaries are minor children, do you want those proceeds being paid out of an insurance policy directly to minor children? You may want,
Or 20-year-olds.
or 20-year-olds even. You may want them going into the trust and the trust then pays them out over time pursuant to the guidelines of the trust.
The idea of a look back period also came up.
Mhm.
Trusts are not automatic. The day you get the trust notarized doesn't mean the trust goes into effect, funded or not. The idea of putting assets, for example, a house or a business, into a trust with the idea of saving on taxes for the next generation, which is kind of standard for these things, doesn't happen immediately. It takes time, just the way long-term care and trust creation or transferring assets is supposed to create the eligibility for Medicaid. It doesn't happen immediately. The government, the authorities, the institutions that control those funds are way too smart for that. They've had more experience than we have. So they control these things, and we have to recognize that if we have any intention of using these trusts for the benefit of, for example, saving on taxes, there is a waiting period. I believe it's 3 years for most trusts. It's certainly for a business. The idea of 5 for long-term care, you get the idea. But again, the idea of using a trust or any of these documents, everything has to be set up properly, and it has to be recognized as to what it takes to make it effective.
Okay. Alan, did you want to say any last? I'm sorry.
Yeah, actually I did. First of all, I want to thank everybody for coming. This is the first time anything like this has been attempted, as far as I know. And secondly, I want to thank you, Debbie, Craig, Lester, for your efforts on this. Again, this is a first, and I hope that everybody that came found it helpful. And our organization stands ready to assist, you know, as needed, because this truly is the only thing that makes all our planning work with Bank on Yourself a reality. That this is the only way of making it all a reality, because things can happen if the elder law part of things isn't in place along with the financial products. So yeah, thanks again.
Well, we have
One more.
Larissa to jump in now. She's got a few things
Yes.
to say.
Let's finish it up with Larissa. Yes.
Yep, we're gonna wrap up. So hopefully what everybody gathered is there are, and thank you, Alan, for this. We're sort of excited that everybody's here. I hope you've gathered that there's a huge breadth of knowledge within our group. With all bring our various experiences and expertise and focus in different areas. If one person does not have the answer or in that knowledge base in that area, we have others to turn to. And then the second thing to glean out of this is that a lot of these questions are going to be specific to your circumstance. So really wanted to go through things that would apply to most people. And then obviously, if you're ready to move forward, then those specifics can dive into in more detail with your advisor. I'm going to screen share here just to wrap up. And actually, Debbie, whenever you want to jump in here, jump in. So we're
Okay, go ahead.
so anybody, so if you are ready to get started, like I say, we adopt that 80-20 rule where 80% of your trust can be finished in 20% of the time. And that's really our goal, so that you do have something in place should disaster happen, to make things easier for friends, family at that time. So how to get started, there's 2 options. One is buy now. So with the link that you have, there's a buy now link that's provided. It'll take you through and walk you through the steps of that, where you can pay online, set up your account. And then the next step after that would be scheduling that first interview session, appointment with our team. The other is starting a trial. And there is also, I think I want to say there's a separate trial link. It's not on the website itself. If you're wanting to still kick the tires a bit, that does both. In either case, you do have to think of the name of your trust in advance, because that's sort of the first step to get it started and frames that. And so you want to put a little bit of thought into that. There is a way to change it, but we hope that's the exception and not the rule. Anyway, and so then you can look more at the platform, self-guided videos, etc. So again, naming your trust during that account setup process, that will legally identify your trust and its assets. Most clients include their last name, as the examples that were given here. The at the beginning should be included. You need to add that. It does not automatically add that in the event that's an important aspect to you. And yeah, as I said, consider your options before starting. And yeah, Debbie, back to you. We look forward.
Okay, so several of you have already I've already talked to about this already. Some of you have already gotten a trial link. Others are like, oh, we're waiting for the webinar because we want to see how this, the deep dive looks, and hopefully that's been really helpful for you. So the big question is, how much is this? It's not free, okay? Because there's a lot here. It's not free, which we wish it could be, but it can't. And so the average trust cost when you go to an attorney, again, it depends on what your assets are, but on the low end is right around $2,500 to $3,000. On the high end, $10,000 or more. Estate Docs Pro offers it for $1,595. Okay, $1,595. In addition, every year, if you want to update it, which I highly suggest you be able to do, is very small, $30 a year, just $30 a year to have the ability to update it. Okay. Now, Estate Docs Pro has offered us a discount because they knew that we were going to do this today, and they're offering us a $200 discount for those who are on the seminar today. And so it'll be $1,395 for those who want it. Now, some of you may want to start right away and say, I got it. I've already had the trial. I want to start this and let's go with it. Others are like, well, I really want to try it myself and make sure I can manipulate it and this is something I want. And that we do, like Alicia said, offer a trial for 15 days. And I can send you a link for the trial. I can send you a link if you want to purchase it, however you want to do. But as soon as you do, we're here to help you get through this. You do not have to go through it on your own completely. And that is what's different about this. It's not just you're here, answer these questions. And, when you fax it back to me, I'll put it through my system and I'll give you a nice binder that you can put up on your shelf. It's much more than that, as you now know. So I wanted to let you know that these are as of today, March 30th, 2022, because obviously prices, we know what inflation is all about. We want to keep it down for now. And so that's what we're looking for. If anybody's interested, and I hope you guys are, because it's something that I certainly paid for myself. I said, this is something that is very important to my family. And I think it's important to all your families. It's just a matter of the time, the energy, and really thinking out what you want to do with your legacy. So that's where we end here. We can do it through email. I will be sending up a follow-up email to all of you, assuming I can through Zoom. Otherwise, if you don't hear from me within 24 hours, you can certainly email me, email Lester, email Craig, however you want to do that. But again, I want to thank you all so much for attending and your great questions. This is being recorded. I will also be sending the recording out, a link to it, so that you all can listen to it again at your leisure. Any last words from anyone else? No? Okay. Well, thank you again, everyone, and have yourself a wonderful night. Bye, all.